SJC-13408, Commonwealth v. Cassandra L. Barlow Tucker, and SJC-13409, Commonwealth v. Matthew J.
So we'll start with Attorney Zelnowski.
Good morning, Your Honors. Jennifer Zelnowski, Special Assistant District Attorney representing the Commonwealth this morning. There is no doubt that this is a tragic case. It's always difficult to hold a parent or a caregiver responsible for the death of a child. However, emotion has to take over and that criminal charges should be dismissed. Here, the motion judge erred by dismissing these indictments under both McCarthy and Odell grounds. There was sufficient evidence to support these indictments for reckless endangerment of a child. This case is not about reasonable doubt, and it's not about guilt.
Can I ask you about the legal standard for a second? In his written opinion, the motion judge sets out the McCarthy standard. Two of our cases, it says it's between one
Yes.
and the other, and then the Commonwealth faults him by saying, well, those cases are sufficiency trial cases, they're not grand jury cases. But he lays out the appropriate McCarthy standard. How else is these facts other than to cite our case law?
And that's part of the problem and challenge in this case, Your Honor, that he does lay out the proper McCarthy and Odell as well. But then his analysis, he starts to go into more of a sufficiency of the evidence. It almost reads like he's addressing a motion for a new trial. I don't know about that.
I mean, he goes into sufficiency. I mean, the bottom line is, what did these parents, what could they have reasonably have known as far as the distress of the child? Was stay in the course, they wrote the right call? I think the factual issue is relatively simple. It's hard, but it's simple to state. I don't get what the judge was supposed to do other than to talk about sufficiency on those particular parameters. I'm surprised when you're trying to say he applied the wrong standard.
Because I
might say he was wrong, but applying the wrong standard, I think, is
way
off.
Well, I think because he does the wrong analysis, his conclusion is also wrong.
How is his analysis wrong?
Well, I think that he does a new trial or a motion for a directed verdict standard in which he really starts parsing apart the evidence that was presented to the grand jury. And he starts weighing...
Stop there. How else are you supposed to find the sufficiency of evidence without parsing the evidence presented to the grand jury?
Well, there are cases about grand jury indictments that discuss that. It needs to be reviewed in the favor of support of the indictment, which I don't think he does.
Well, that's what he says. You're saying he didn't do what he said he did? I mean, you can quibble, of course you can, with how he applied
Sure.
to the McCarthy standard, but to say he didn't use the McCarthy standard, I think is really far-fetched.
I think in my brief I outlined that he certainly identifies it, but then I think he takes his analysis too far, and he does apply, he makes the statement that this case is somewhere between Gallison and Michaud, and in one of those cases, I'm blanking on which one of the two, but this court also made note that in that case, they weren't addressing the grand jury indictments, but in one of them, they say there was enough evidence for the indictments to stand, so they were going back to say, some of these cases might make it through the indictment process, but because they're difficult cases, they may not make it. Acknowledge that as well. That may be the case here. The evidence, I think, is a close call. But I think for probable cause, in the favor of allowing the indictment, the review of this evidence should have been on the other side by the judge. It seems to me that he's trying to find ways to show that these defendants didn't do the things that the Commonwealth presented as evidence that they did. So to me, I get that it's a very fine point, Your Honor, but I think that that's part, and that there was sufficient evidence when you look at it in favor of the allowance of the indictment. In particular, I think these are caregivers who had a duty to act. They did so in a wanton and reckless way. And when you look at the evidence from the medical examiner and from the pediatrician, and also from the speech pathologist, the child passed away, she makes a comment to the defendant that she thinks that child needs to go to a doctor. Well, the motion judge turns that around and suggests that because she didn't say it was urgent, it didn't meet the standard. But he's turning that evidence around. Similarly, when he is weighing out some of the...
Why do you say that's not what happened?
Because there was no question about whether or not, nobody asked her, she felt this was emergency room situation or whether it was urgent, but she did say that she described what she saw. She saw a prominent and persistent cough, that he was having difficulty breathing, and that he looked ill. And in her testimony at grand jury, that she felt that that child needed to go to the doctor. That's what needed to happen here. That's the duty, and that's where the failure was.
Could I ask you, first of all, I just want to, you agree that if you're going to apply a probable cause and you're going to apply a McCarthy standard, you still have to go through all the elements and examine all the elements in order to determine not whether it's a required finding, but it was, and that when the judge goes through carefully, he is applying, there's no reason to think he isn't applying McCarthy. There's nothing about going through the elements that suggests you're not applying McCarthy.
Oh, no, he of course, he has to go through the elements and certainly review the evidence. I think his view of the evidence is not in favor of the indictment, which is what the standard should be on a McCarthy motion.
Is there any difference between the Cassandra and Matthew? Is there any difference, for instance, when Matthew walks by the crib in the video that differentiates the two?
I think, yes, I think there's some differences on the facts. I certainly think that that is a key part of this case as it relates to Matthew, that you can see him on the video walk right past the crib where you can hear the child struggling with every breath. And he doesn't look, he doesn't go over to see if he's okay. He just goes in, puts the other child in the bed, and then walks out. I think in that moment in time, that shows his reckless disregard for how ill the baby was at that point in time. I think with Cassandra, we don't have that kind of video view, but I think if there's a couple things that the young child that puts the baby in the crib, you can actually hear the breathing of the baby and the coughing and the choking just before they come in the room. So it wasn't like it just started, and I think reasonable people can agree that that sound and that struggle and that choking was happening before the young child put the baby away, or put the baby in the crib. But before that happens, in another place of the house. So I think at that point in time, Cassandra would have heard the sound.
Isn't it more important that the child's been sick for 2 weeks, right? In the light most favorable to you, right? The child's, when did the DCF worker, how many days before did she say the child should go to the doctor?
It's not a DCF worker, it's early intervention speech pathologist. She is there on February the 14th and says that the child needs to go to the doctor.
So that's a week?
That's about 3 days.
3 days.
3 days. And there is also evidence from both defendants' statements that the baby had been sick for about 2 weeks. The first week he seems to be mildly sick, has a low fever. All the kids in their house go through this, as we all know happens, except this one stays sicker longer. And I think that when, Justice Capper, when you're talking about the 2 week time period, that's crucial.
So the testimony on the, because it's hard to measure recklessness in a second, right? But the issue is, should they have called the doctor? Should they have taken the child to the doctor? And and so the kid's been sick for 2 weeks, and he's been showing a fever off and on during that entire 2 weeks. It was, again, the light most favorable to you. I understand.
Sure.
Yeah.
So the evidence was during the first week of his illness, he was no higher than 100. And then in the second week of his illness, he goes over 100 with his fever, as high as 102. That's what Matthew's statement indicates. So somewhere around that time is probably when they should have been on notice than the other children and required medical care. In addition, in her statement to the police, Cassandra indicates that she is aware that he has, and these are her words, compromised lungs, because he had been sick earlier in December. And yet, when he symptoms,
Although
there is no call to a doctor.
Compromised lungs is strong, right? The doctor, Sumar, thinks that it may be a dog allergy, right?
Absolutely.
Right, okay.
Yeah, the earlier part, and then in December he goes in and he has some kind of congestion and he gets the nod for 2 days. I agree that that is a strong word, but that's the word that she uses when she's telling the police about, well, she tells them that she called DCF to take him to the doctor, but we know that there's no evidence that that actually happened.
Can I ask about some of the extraneous stuff?
Sure.
So the judge is focused on 2 different aspects. One is the evidence sufficient. 2 is the evidence, the way it's presented. And with one of the kids, I can't remember the big kid, whatever he's. I don't want to use his exact name.
Sure.
But so there's some suggestion that at least Cassandra makes negative comments about taking kids to the doctor.
Right.
In this blog, right? That it's burdensome. So does that seems relevant, right? Some of the other stuff seems irrelevant. Whether they got paid after the child died seems really irrelevant and,
Sure.
and inflammatory. But the other
Yeah, in
part-
retrospect it does, yes.
yeah, but, well, even then it should be. But that part is important, right? That, we're trying to measure why they didn't go to the doctor, right? So.
Yes, I outline in my brief, and I think it's an important point. The judge overlooks it because he's so focused on this potential prejudice. But those posts, and the prosecutor says this, they're put in for state of mind, and it goes to the wanton and recklessness.
Now that can I?
The financial the fact that they
No, I'm sorry. The other part about the other child.
I mean,
that they were cared
marginally
for.
relevant is what happens with the kid named Big D and whether or not you sought care. I'll give you that. But the other stuff is incredibly inflammatory and not relevant at all. How probative of the duty of care is it paid once the child passed away?
I don't think it was, I agree with you that looking back, it's problematic. At the time, it was to a setup that there was a duty of care.
That's not an issue. That's just.
I understand what you're saying, Your Honor, but I don't think, even if that's the case, even if this court says that it was shouldn't have been put in and it was inflammatory, it's a very minor part of the evidence that was put in this case.
I think you're too big a hill on the pay. I think you got to go to Mayfield and
That's where I was going, Justice Lowy. But when you go to that analysis, which it doesn't seem that this judge did in his decision, and I think I'm pretty safe in saying that, he doesn't get to that last part of Mayfield. And this court recently addressed that in Brown. Peter put in volumes of DOC records that laid out all kinds of disciplinary reports and all kinds of poor behavior to establish a relationship between the co-defendants. And this court in that case said, well, first of all, the prosecutor gave the proper instruction following right after the blog posts go in. But I think more importantly, this is not a major part of the case. It is 3 pages of documents within thousands of documents. And the sergeant that testifies simply says this is what. There's no suggestion that they were defrauding or doing something nefarious.
You can see this was a mistake.
I think it was a mistake in retrospect, yes, Your Honor. I understand.
Your best, you keep saying in hindsight, argument that it was not ex ante affirmatively irrelevant and just prejudicial.
Well, I don't think it was completely irrelevant and prejudicial in a way that would require.
So the financial documents, I mean, that just seems. Do you have an argument on relevancy on that?
Yeah, the argument was that it was put into a staff relation.
They were paid afterwards have anything to do with the duty of care.
There wasn't really. that was just what the document said, and the sergeant was just explaining what the document said. There was no suggestion that there was any kind of nefarious conduct. It was, they were paid and that established the relationship. They were overpaid and then they refunded the money, which in these types of situations when children are being moved from DCF, that happens. But again, going to, as Justice Lowy pointed out, I don't think under Mayfield, those factors, this small, tiny piece of evidence, prejudicial or not, in a grand jury situation is enough to dismiss the indictment,
about,
especially with all the other evidence. I'm sorry, Your Honor.
Oh, no, it was me, I interrupted you. But before we lose you, what about the 12-year-old daughter's testimony? And is there a sort of an Odell distortion as it relates to what is put in and what isn't put in?
I think it was I do think it was a misstatement that the mischaracterized what she had observed in a very specific sense. But I will say that certainly the grand jury had access to those statements. They could have watched the statements in their entirety. Obviously, we presume that they reviewed it carefully. But again, I don't think it's something that rises to the level, especially in light of all the other evidence that came in with regards to how sick this child was and how dire his situation was, that this would be something that would be grounds.
Doesn't the nebulizer treatment show that they were doing what they thought they should be doing, just within their own experience?
Well, there's a couple of issues with the nebulizer. First of all, it wasn't because he hadn't received any medical care for this condition. It was prescribed about 2 months
This
earlier.
condition is which, can you separate out which condition? you're
Sure,
talking about?
the ultimate pneumonia that led to his death.
Okay, but they didn't know he had pneumonia.
They didn't, because they didn't get him the medical care that he needed.
But how
make
would
that
they know
determination.
that? How were they to know that the nebulizer treatment that they had was not what they were supposed to be doing? I guess I'm just concerned that we're putting too much on what the parents are expected to know. They're not doctors. They have had experience with sick children, and so they did what they do with their sick children.
Sure, but I think part of the challenge there, Your Honor, is that he was continuing to get more and more sick in those last couple of days before he passed away. So the nebulizer may have given him a brief amount of relief, which, that's what their statement is. The ME testifies that it likely wouldn't have helped by the end because the lung was so blocked that they could have given it to him and it really wouldn't have made its way into his lungs to help anyway, and that it wasn't the right treatment for this type of infection. And that's part of the problem, is that he had he was getting sicker and sicker. The other children had gotten better, and there was no medical care to address the fact that he wasn't getting better. So it wasn't that he had the same thing that they had, or maybe he had the same cold, and it developed into something worse for him, given his status, but they didn't react to that. There was no medical care, and had they called the doctor, maybe the doctor would have prescribed the antibiotics that the ME talks about. That could have been the treatment in this particular
But strep's
case.
pretty unusual in this circumstance.
It is for this age. I believe the pediatrician does say that, but he also does talk about how significant the breathing is in this child, and that if a child like that had been brought into his office, he would have sent them immediately to the emergency room. So this is not sort of...
Child, whatever, big.
I think it was about 2 years before this, and he had been coughing up pus. And yeah, there's obviously a difference, I think, between child.
Took that 4-year-old to the hospital.
They
right?
did take that
Or
child to the hospital. They also called the doctor about one of their other children who had been sick, because they were concerned about her, but her fever had never risen as high as this child.
102 is not that high for a little kid, right?
I think it is, but I'm not a parent, so I don't take babies' temperatures all that often, but I think 102, both the doctor, the pediatrician, and Cassandra also says that when your fever gets to that high, watch, but nothing happens. And in addition to having a fever, he had other signs that he wasn't well, that he was coughing and struggling to breathe and was looking ill and was lethargic and wasn't drinking. And they comment that his diapers were more dry. And this is all happening in the days before. So I see my time's up, but I just want to make this point real quick. And they also indicate to the police two things that are problematic. First, that they had called DCF to take him to the doctor, which did not happen. But to me, that suggests that they understood that this child needed medical care. And then there is the comment in which they joke going to the doctor with one of their other kids and taking him along to be seen. That, to me, indicates that they had an awareness that this child needed medical care, but they didn't act on that duty. If there are no further questions, Your Honors, well, thank you.
Okay, Attorney, Daniels.
Good morning, may it please the court. My name is Attorney Josh Daniels. I'm appearing for Matthew Tucker. With me is Attorney Nancy Dolberg, who is appearing for Cassandra Barlow Tucker. I don't know if they're here yet, but I know that the Tuckers were planning to attend. Just by way of a roadmap, my focus will be on probable cause, while Attorney Dolberg will address the material impairment of the grand jury. And together, we're asking you to affirm Judge Agostini gave.
So we laid out the factual issue about whether or not they should have gone to medical intervention. And I think, as I read the record, and correct me if any of these are wrong, okay? As far as what the parents have evidence, we have a persistent cough, we have a lack of fluids, a fever, and lethargy, correct?
We have an on and that's mostly correct, I think.
Tell me what's wrong about that, or and if there's anything I'm missing.
So there is some suggestion that he's drinking less. They are making concerted efforts to keep him hydrated. There is evidence that he is there is evidence that he is lethargic. There is evidence of persistent coughing. And the fever, I think, is mostly described as off and on. It comes on in the morning, and then as he gets fluids into him and goes throughout the day, it comes down. It comes right back down.
There was some testimony, I think it was from your client, about feeding the, administering fluids by an eyedropper.
I think that was liquids. There's also mention of a sippy cup. I forget which parent mentions that.
But it was at the state where they had to use.
A syringe to push fluids, yes.
Right, which is concerning.
It is, but I think where I plan to begin is I think we need to unpack the nature of the risk that needs to be appreciated for recklessness, because I don't think it's actually in the abstract whether you know that this person has to be taken to the doctor. The risk is more specific than that you need to appreciate. The reasonable person must appreciate that there is a high degree of likelihood of death or grave bodily harm, not just continued discomfort, not just continued sickness. And so I think we need to keep that the nature of the risk that needs to be appreciated in mind. The other thing I want to sort of stress, I plan to end with this, but I may not get there, is...
But on your first stressful point,
Yep.
What about the evidence that Justice Gaziano just summarized doesn't lead to probable cause that would have understood the risk to the baby?
I think where it falls down is sort of high likelihood of death or grave bodily harm. As I think it's undisputed that
I think
they know that
respectfully, I think you may be misstating the standard. As I read Levesque, Walensky, in the model homicide instructions, a failure to act as wanton and reckless involves a high degree of likelihood that substantial harm will result to the person to whom the duty is owed.
Correct, and in Carrillo,
You said death, or
that's how Carrillo defines what substantial harm means in this context, is death or grave bodily harm.
well, the Carrillo context was an overdose, correct?
Pardon?
Carrillo was an overdose.
Yes, but it's still about, it's still involuntary manslaughter, it's still recklessness. I think it's...
I understand what Carrillo was about, but anyway, we'll look at that.
So he's 10 months old, though.
7.
And sorry, did I cut you off just one?
It's 10 months, right?
Right, the child's 10 months old. And that video is deeply shocking, right? It's just heartbreaking to listen to that level of roaring coming out of that little kid. That's the hard part for you, isn't it? To deal with that. That's not, I mean, that's not ordinary. It's really loud, and the kid is clearly gasping, right?
So a few things about the video. The first thing I just want to re-emphasize again is, as I mentioned in my brief, there's a real site bias here because everyone who has ever seen that video has done so with the foreknowledge of what the outcome is. And I think that sort of inevitably colors how bad it sounds because we know what it leads to.
You do a very good job of that, but again, it's the level of the versus getting on the phone at least and calling a doctor or taking the kid to a doctor, because it's not an ordinary coughing sound, right? It's just, it sounds.
So the other thing I would say is to remind us all that recording just often distorts even as it captures, and playback distorts again. And to unpack what I mean by that.
But you're at the probable cause standard, right?
Correct.
So I think, those are great arguments. But right now, we should stick to
At
basics.
the very least, I think it's relevant in terms of deciding whether this is close enough for the grand jury for the Odell arguments, not to preempt what my sister is about to say, for those to actually matter, for there to be a fair distortions in the grand jury process really did matter here.
Could you argue the other way, though, as it relates to the blogs and the discussions of how frustrating it is to go to the emergency room, how frustrating it is to deal with health, and the palpable reticence that Cassandra's discussing about the whole process of dealing with a sick child after hours?
What my colleague is going to say. I think one thing to sort of keep in mind is also that the Big D situation is different in ways besides age. It's also that it's hard to suss out what he's underreporting his symptoms, but there's also suggestion that he's overreporting his symptoms because he likes how the medicine tastes. The last thing I just want to wrap up with, if that's all right, is I think we need to be really careful not to get so hyper-focused on the specifics here because and it is voluminous, but we need to not lose sight of the basic line drawing problem that this case represents, which is that the kinds of decisions that we are talking about here, how serious is this? Do I need to take my kid to the doctor? Is what's in the medicine cabinet enough? Is this a dire emergency, or is this just a bad night? These are decisions that all parents have to make constantly. They usually have to make them on the basis of imperfect information, equivocal information, incomplete information, and it can be really hard to suss out. And what this court has said for going on 40 years now is that while it's possible to make these sorts of misjudgments, those misjudgments just aren't recklessness, no matter how terrible the consequences end up being, even the death of a child. I think Judge Agostini appreciated all of this, and I would urge this court to do the same and affirm his decision. If there are no other questions, I'll turn it over.
Okay, thank you.
Thank you.
Okay, Attorney Dolberg.
May it please the court, I'm Nancy Dahlberg on behalf of Cassandra Barlow. Before I begin on the Odell argument, I just really do want to point out, because I think the Commonwealth has overstated the testimony of Miss Wood, who was in the home the 3 days before. What she actually said was she vaguely remembered having a quick conversation that looked like maybe he needed to be seen by someone, and also had a vague recollection of Cassandra's intention to bring him to the doctor if his condition worsened the next day.
Can I ask one follow-up on that?
Of course.
Did she actually, the child was ill, right? So she doesn't get to spend much time with the
It's working with the younger
Right.
daughter in the family who has cerebral palsy.
Right.
Not cystic fibrosis, as is something I'll get to, but they were in the same room.
So they're in the same
Same
room, but she's
room
not even
and-
there for that child.
Right.
Maybe you should go to the doctor on that kid?
Well, she notices that he has a respiratory cold. That's how it struck her. And she makes a comment like many of us do. Oh, do you think should be seen by anyone? Now, the whole family had been sick. In fact, the 2 weeks at that point, and had just, all her early intervention appointments had been canceled until that
The
day.
youngest daughter was how old? And she
2,
had-
I think.
And that was the child with cerebral palsy?
That is a child with cerebral palsy.
And
yes, Your
and she
Honor.
was told not to bring that?
But she had really about the same length of illness.
So turn to the issue that you
Yes.
have divvied up with counsel.
Yes. Please,
Before we sidetrack both of you. The issue of a former trial judge, you would say, boy, that's not admissible and it's overly prejudicial and the probative value is minimal. We're in the grand jury stage, however, and what concerns me about the motion judge's decision is he never mentioned instruction the Commonwealth gave the grand jurors in his analysis. Is that a problem?
I would say it's not a problem for many reasons. That instruction just went to the blog post. It did not categories that I hope to get to today. It gave the jury permission to consider all of the blog posts as to the nature of a relationship that was totally removed and respectfully, I think, highly irrelevant to this situation, not just highly prejudicial, but highly irrelevant because it was an older child with a completely different set of issues. And as the DCF worker said, this was about Cassandra venting about shortcomings in the foster care system and difficulties of fostering. It did not have anything to do with the care of children.
Really?
That was not presented to the grand jury.
I agree that a lot of what the officer testifies to seems inappropriate, but some of it, particularly regarding the big child, seems relevant. That one, they're angry that they have to go to the doctor, that how burdensome it is, that this child had strep, that it's, meaning they must have got some discussion about what strep can mean. It doesn't seem, that part seems relevant. It may have been layered on with a bunch of stuff that's inflammatory, but that part seems quite relevant when the issue is, did they not go to the doctor for the right reasons or the wrong reasons, or reckless reasons or negligent reasons?
I would like to respond to Your Honor and then get back to, and I would like to finish also
Yeah, no,
that,
I
and
don't
then
want
do
to cut
nothing.
I don't want to cut Justice
No,
Gaziano off.
No, I will get to everyone. Thank you. So this was a child who was much older than the 10-month-old we're talking about here. The illness that this 10-month-old had was very rare, and I can't tell you like one in how many thousands. Even a doctor wouldn't suspect that a child would have this strep A, and they didn't have any idea that their other child had it until after, unfortunately, the death of this child. So all of this about Big D was about venting with DCF. They didn't apparently give a mass health card. We all know it's impossible to go to the emergency room with a sick child, so that's not something you favor. In this case, Big D...
You don't go to the emergency room? A lot of us go
No,
to the
no.
emergency room.
Unless someone's really sick, do you want to spend all night in the emergency room? But that's what that venting was about was,
That's the
I
issue.
wish Big D could have told us sooner so that we could take him to a routine appointment. So as to the instruction, and I'm happy to return to
No,
this as well.
go
but
to Justice
As to the
Gaziano.
instruction, not only was it only about the blog post, not only did it give, unlike the other cases that have found instructions to be effective, permission to the jury to consider all of the information, it was given, even though there were at least 15 pages devoted just to the blog posts, it was not given at the beginning of that. It wasn't even given at the end of that. It was given after after the prosecution, after the jury went to lunch.
Yeah,
So
I
would,
in your brief, when you said
Oh,
it was given.
I'm sorry.
No, when you said it was given after lunch, I think it was, because we've never said in
No.
any reported decision, forget an limited instruction, it was given after lunch, or if it was given at the end versus the beginning.
I
So-
agree, Your Honor, but it was not given at the beginning either, which is
In your
usually when
well-done
limiting
brief,
instructions
I
are.
didn't really get that part
So
of it. I agree with that part of it.
it wasn't given at the beginning, but I don't really think that any instruction, on top of all of that, I don't think any instruction would have been effective here because the Commonwealth engaged in the pervasive use of false and misleading evidence, really to depict a wildly inaccurate picture of these people.
We're in Mayfield now?
Yes, and I would say the judge clearly did find the third Mayfield, found that this evidence undoubtedly tended to influence the lens through which the grand jury judged the Tucker's conduct and choices with respect to the child's illness. His decision was about Mayfield. So I disagree with the comment. The combination, and I would like to run through briefly, and if I may, what led to this gross distortion of the Tuckers as a kind of neglectful, uncaring foster parents who wouldn't want to take children to the doctor, who were and who would be callously indifferent to a child's medical needs. And that does start with the financial information, and I won't belabor it because I believe the court recognizes that this information about what they received in payment, not only for the care of the child, but for their adopted children, was, emphasized by the grand jury. It was presented to them. It was in testimony, emphasized to them. In terms of the blog posts, I really, the language that they used was very inflammatory, and it was introduced by the district attorney as meaningful because, again, the Tuckers saw this as a job for money and didn't like to take children to routine medical care appointments, which later they provided other information about that was deceptive, I will get to. In terms of the judge's findings, they stated falsely that the Tuckers had been disciplined. That was false. And in fact, they never told the grand jury what the social workers actually had to say about them, which was typically, let's see, Matthew and Cassandra are probably honestly two of the most conscientious, engaging, forthcoming foster
That was
parents.
buried in the written documents.
That is on a DVD, one of 4 DVD workers, and then there were other DVDs. There were 2,000 pages.
And I take your quote to
Yeah,
Justice
so
Hines' appeals court decision.
I'm sorry, I don't think that's a satisfactory excuse. That was hidden and does bring to mind a very nice comment made in another case and I don't hear, but the Commonwealth can't hide the evidence and expect the grand jury to find it.
That was a Justice Hines quote.
I'm sorry.
That's Justice Hines' quote.
Yes, Justice Hines and Hunt. It's a wonderful quote. This kind of, it is clear, by the way, that the jury was affected by what the judge complained about because they wanted to know, what happened to Big D? Even the Commonwealth concedes that the exchange about that would have led the grand jury to believe that he was removed for substandard care, and the record indicates otherwise. As to the statement of the daughter, the true statement of their daughter, who was described as being 12, was that, let's see, he was asked by the district attorney, did he watch this video of the statement, and what did the daughter have to say? And he said that she said he was struggling to breathe the day before he died. Actually, what she said, that he was coughing a little bit and having a little trouble breathing, that he was getting better, seemed fine, and pretty cheerful. But she never said he was struggling to breathe, and the juror's comment in response to this is so significant. I'm struck that their 12-year-old daughter recognizes that the child is struggling to breathe, and yet the father states that they believed he was going to be okay. And then the juror asks the trooper whether you believed him. So it's clear from all of this that the jury was, the credibility of the Tuckers was undermined by this false testimony and their failure to indicate the whole statement, which supports their statements. And by the way, this misstatement and omission immediately followed Matthew's statement, which immediately followed Cassandra's statement. This basically said, you know, when they said that he was getting better, a lie. And
The synergistic effect of an Odell and a Mayfield violation.
absolutely, Your Honor.
Can I ask you something
Yes.
to parse it out a little bit? If we agree with you as far as the fairness of the grand jury presentation as it relates to, call it, bad act evidence or extraneous information, but we disagree with you as far as the duty of care part of it, is a remedy, motion to dismiss is allowed, without prejudice is allowed, and they can re-indict it in the proper manner?
Dismissal without prejudice the Commonwealth can certainly re-indict. I'm not sure I understood what you.
Right, so if we find the evidence is insufficient, of course, that's a different
Yeah.
story. But
Oh.
if we find the evidence sufficient,
Yes.
but we agree with part two of your argument, the remedy is to,
The remedy is to
If they want
dismiss
to.
without prejudice.
And then
the
whatever
Commonwealth would have to
happens.
make a decision. And that is what the judge did here, and that's what we would be asking this court to do. If I may, I just want to get into, because this had come
Is that
up.
true regardless of, even if it were both prongs were lacking, that they didn't present sufficient evidence, that would be a dismissal with prejudice?
it's without prejudice. We don't know what other evidence they have, so it'd be without
Yeah,
prejudice.
the judge found dismissed without prejudice.
So the Commonwealth could have just tried to re-indict without having appealed the decision.
Yes, yes, absolutely. Let me just mention, this theme about not wanting to take children for routine medical appointment, is really a gross distortion, and it was created by the Commonwealth. Of course, there's evidence in the record about this youngest child who was a foster child who was adopted and has 23 medical people. But that said, the Commonwealth went out of its way to suggest that the Tuckers were responsible for a December 18th medical appointment, which might not seem important, except that it was a medical following one he had before, which he was taking to DCF. And the Commonwealth set up a scenario where they read from a manual that said foster parents are responsible for making and keeping these appointments. Was the child taken? Grand jurors were asking, did the Tuckers ever take the child to a medical appointment after, this December 18th and before the 2-week illness? And in fact, what they never told the grand jury is what the social workers had told them at length, which is there isn't a set policy between DCF and foster parents as to who would take a child for a routine appointment. Cassandra indicated in her statement that she believed the DCF worker was going to take him to the appointment had she had the prior appointment. But instead, they left that out. They also did not tell the grand jury that, in fact, 2 days after December 18th, Cassandra sent an email to all the DCF workers saying, hey, what happened to that appointment? And a supervisor responded saying, we'll look into it. And they never got back to her.
Can I ask a follow-up question with Justice Gaziano just pointed out?
Yes.
Are there good cases, are there good cases that we can look at where the sufficiency thing is clear, but the misconduct thing requires a dismissal without prejudice? Are there a couple of good cases where you have parallels, where there's plenty of evidence, but at the same time, what the Commonwealth did requires a do-over?
So in Washington W., which ended up being dismissed with prejudice for other reasons, Justice Gantz said that there was probable cause, there was sufficient evidence, but the grand jury had been tainted by, in that case, an omission that went, directly to the case.
Washington W is a good case for us to look
Yeah.
at.
Yes, I think so, Your Honor. There are, Mr. Daniels and I also provide cases about probity, the prejudicial more than probity. But this is, I would have to say, was a very pervasive use of both misrepresentation and omission to paint these folks in a particular way that really would have affected the grand jury's decision. I just want to make a couple more points, if that's all right although, and as I mentioned about the cystic fibrosis, a juror misunderstood and an incorrect evidence was elicited from this same early suggesting that this youngest child had cystic fibrosis. She doesn't. She has cerebral palsy. The Commonwealth knew that. And ordinarily, you know, it was not introduced by the Commonwealth. But the Commonwealth has an obligation not to allow false evidence to go uncorrected. And I have to say...
Wait, can I interrupt for a minute, counsel? Oh, wasn't the young girl is being treated with a nebulizer, so regardless of whether it's cerebral palsy or cystic fibrosis, she's being treated with a nebulizer for a lung condition or a breathing condition like the other child was.
Really came up in the juror asked this witness, didn't the older child, so she was very confused, have cystic fibrosis? And the reason this becomes important is this grand juror says, so that one could assume that the foster parents would have some understanding of a respiratory ailment toward like the sound of one. So this may go back to the video that the justices were talking about. That's a very obvious example of the jury being prejudiced.
That's also, counsel, isn't that also just evidence, whether it's prejudicial? The question is whether it's unfairly prejudicial. The grand jurors could look at that video and come to their own conclusion. Can you also address how the parties' misrepresentations to the police affect this case, and that both the father and the foster father and the foster mother say that they, in fact, that the foster mother put the child to bed, when the video clearly shows that's not the case? How do you handle that kind of evidence in this context?
Well, I would say as to a misstatement made in the aftermath of this kind of trauma, it does not go to what their state of mind or
But this was more than a misstatement, however. This was, when you read those statements, you see that the foster father and the foster mother are saying the exact same thing and going on about what great caretakers they are and how wonderful how much they understand the system. It doesn't seem like a misstatement in the context of reading that.
Well, Your Honor, I would disagree. I think that, you know, their assessment of what occurred is what they recalled. But in terms of the putting him down at night, I think that Cassandra could have been confused with a nap. But I would certainly assert that this does not go to whether they were aware at the time that he faced, you know, that he had a deadly illness.
Can I get you to just say the second thing you wanted to say very quickly?
I think that I'm probably, unless there are questions, and I apologize, I may have forgotten.